Please, Your Lord. My Lord, I'm praying for a listing of a PIL on coming Thursday or Friday, my Lord, pertaining to establishment of medical college at Karimganj district. We have filed it yesterday. Can it be taken up this Thursday or Friday?
Get it listed on Friday?
Yes.
Friday?
Deeply.
May I please, Lordship? My Lord, we have filed an appeal yesterday. Our electric connection has been disconnected in the year 2021 by the judicial authority in illegal manner in violation of law. Some urgency is there, my Lord. Our industry is closed since 1.5 years.
You are against a single bench order, please.
Yes, we have
When was
challenged.
the order passed, sir?
Order was passed that I shall have to pay the entire assessed amount of 85 lakhs at a time. Whereas the law says
What is the
something
date
else.
of the order passed by learned single bench?
My Lord,
When was your writ decided?
10/2/22,
Okay, you get it listed on Monday, Tuesday,
Tuesday.
next Tuesday. Monday, give it on Monday.
But it is earlier.
All right, give it on Friday.
With the consent of the other side, may I pray for 2 weeks' time in item 7, Lordship?
Number 7. You are representing the petitioner.
Petitioner, Lordship.
Counsel for the petitioner pays for time. The other side has no objection. List for hearing in first week of May.
Much obliged.
May it please your lordship. Lordship, with the consent of the other parties, I beg to mention item number 23 of daily list. Lordship, the conducting council, V. Pathak, is out of station, so I'm praying for one. The matter may be listed on after 1 week.
Counsel for the appellant pays for time. The other side has no objection. Re-notify for hearing in the second week of May.
Lordship, on behalf of Mr. A.K. Purgasto, Lordship, his elder brother expired, so kindly fix the matter.
Which one, madam?
Lordship, item
Item
7.
7.
Item 17.
1 second.
Second week of March, Lordship.
Item number 17. A counsel for the petitioner. Proxy counsel appearing on behalf of the pays for time. The other side has no objection. That the petition be listed for hearing in the last week of March.
Item number 24 of supplementary list.
Single.
Yesterday, this court was surprised that there were earlier petitions which have not been disclosed. So we hope that you have completed your instructions in that regard.
Yes, Milord, we had talked with them. They have told us under what circumstances is done. First, Milord, the present petitioner filed the writ application 601819,
Yes,
praying for, because earlier, Milord, they filed FIR and at the same time, Milord, informed the government. And the deputy commissioner also filed an FIR. But government did not take any action. So they are in first petition, we have asked for direction to the government to take steps in pursuance of the deputy commissioner's FIR, our FIR, and other information. But they did not do anything. Then we came before the single judge asking for a direction to the government to do something. While the pendency of that petition, Milord, the government started moving and initiated the process. Thereafter, my lord, the order, page 8, we have withdrawn that petition with a liberty to file it again. The order dated 12/11/20, probably your lord has got a copy.
Question here is, sir, the question here is whether there is a disclosure of this fact in the present writ petition. And,
I am coming to that.
okay, wait a minute,
12/11/2020.
this 12/11.
Yes. There the liberty was given to us. Counsel for the petitioner states on instruction that the petitioner does not want to further pursue with this petition. Writ petition stands closed. Liberty to approach again is granted. So, my lord, since the government started taking process in pursuance of our request, then we came, and thereafter, since government has done it, we have asked for, requested the court to
Yes.
allow us to withdraw the petition with a liberty to refile it. And that was a petition, not a prayer like this. That was a petition for asking directing the government to initiate process. But that has already started. That's why, my lord, we have withdrawn it. This is regarding our petition.
Sir, would you like to explain the order passed in PIL number 1/20?
PIL we have not filed. It is a different order altogether. We have nothing to do with it. And in PIL also, court has said certain things. That is, if we closely read it, asking the court, asking the government to take some action. If your honor, once I can read the order of the PIL.
You change the face, you change the title and file same matter again and again.
No.
Are we supposed to entertain such writ petitions, sir? No, not by.
PIL is not filed by us.
All said and done, sir, were you not required to mention about your earlier writ petition in this? While
No, that PIL we do not know.
forget about the PIL, what about the writ petition?
Read petition, my lord, since liberty is given.
But then irrespective of the fact.
No, that I
it had
agree.
to be disclosed.
That I agree. But this aspect, what your lordship says that we suppress it, there is no question of suppressing it because liberty was given to us. It is in our favor. So there is
There
no point.
is a slender difference between non-disclosure and suppression. Not much of a difference.
Read petition was filed by the other side.
It was filed by? The writ petition was filed by
Not filed by us.
Anti-Corruption Liberation Unit. No.
No. We are response number 7. There we respondent number 7.
Okay, understood. Very good. Yes. And this is the writ appeal.
Read appeal.
Very well.
So, my lord, would your lordship like to see the order of the past in the PII?
Yes, we are having that.
Your lordship will get that in page 10.
Yes.
All Assam OBC Students Union has preferred this petition in purported public interest with the plea that the fake birth certificates are being issued. Although representation and complaint are made in context of the issuance of such false fake certificates issued to secure government jobs. No action is being taken. We have Mr. B. Kaushik, learned counsel for the petitioner and have gone through the pleading. In para 7 of the petition, it has been pleaded that the respondent Rasavan, serving as circle officer in the state of Assam at Meghalaya, obtained selection in Assam land revenue cadre through combined selection process conducted by the Assam Public Service Commission in the year 2008 by relying on the fabricated OBC caste certificate. Reports were published in TV channel. It has been pleaded that thereafter the petitioner conducted inquiries in regard to the issue and came to know that another association of Jorat district had filed a writ petition belonging to similar grievance. The said writ petition being number so and so and is still pending. It has been pleaded that though inquiry was conducted in the context of claim response number 7, however, action has not been taken. On going through the petition, we find that no proper foundation has been laid. The petition does not bring out the provision of law under which such certificate are issued. The petition does not elaborate as to which authority is required to issue such certificate. The petition also does not indicate as to what are the criteria of considering whether the person belongs to OBC and backward class. Who had find this case appears to be in personal interest rather than public interest. We have referred to the last order issued by the petition number so and so. Durniti Virodhi Oikko Mancho versus State of Assam and others. The said petition has not been filed in public interest. Learned counsel for the petitioner has informed the court that issuance of fabricated OBC certificate has been challenged by virtue of the said petition. We, having considered the nature of the pleading in the petition and find that neither there is any averment or allegation indicating non-implementation of a statutory provision which affects the public at large. So there is any matter. Malik.
Mr. Bhattacharya, what my lord, the Honorable Chief Justice is saying, that whether the decision of the learned single judge on merit is correct or not, that is another matter. but merely because you were the informant, your clients were the informant, and therefore implicated as a party in the writ petition. This being an issue having a bearing on the job of the employment of the writ petitioner, we would not entertain this appeal at your instance, but if the state or the advisory body comes against the order of the learned single judge, that aspect of the matter, we'll keep it open. What do you say on that?
No, my lord, your lordship will see. The Supreme Court case, the Madhuri Patil's case, has laid down the guideline. There it says that if it is obtained by fraud, then it becomes the responsibility of the court to look into it. I like to place the paragraph 13 and 15 of that case. That will clear. This is a case of medical admission, my lord. Page, paragraph 13. Yeah, photocopy, page number. Whereas at page 294. 254.
Are we, the inquiry, there is no dispute that the inquiry is in favor of the employee. That is a fact. So are we to allow any third body, third person to delve into these inquiry reports? That will be opening a Pandora's box. We allow anyone to say
No.
that, no, sir, I am not satisfied with the inquiry report.
Thereafter, as per the Supreme
Are
Court,
we sitting in appeal?
the guidelines given by this inquiry report is not final.
Maybe the state has got its own mechanism. Let them exercise. But why should the writ court say that no, we are not satisfied with the inquiry report, which is in favor of an employee, and keep on making unnecessary encroachments on the right of the employee.
Below the other reports by the
And in view of the fact that the earlier writ petitions
inquiry,
have been dismissed,
inquiry report is the part of the process. On inquiry report, speaking order will be passed. And that has been detailed by this decision, my lord, how it has to be done. May I place that? Paragraph 13.
yes,
The admission wrongly gained or appointment wrongly obtained on the basis of the false social status certificate necessarily has the effect of depriving the genuine scheduled caste or scheduled tribes or OBC candidates as appointed in the constitution of the benefit conferred on them by the constitution. The genuine candidates are also denied admission to the educational institution or appointment to office or post under a state for want of social status certificate. The ineligible or spurious person who falsely gain entry resort to the dilatory tactic and create hurdle in completion of the inquiries by the scrutiny committee. It is true that the application for admission on educational institution are generally made by a parent, since on that date many a time the student may be minor. It is the present or the parent or the guardian who may play fraud claiming false status certificate. It is therefore necessary that the certificate issued are scrutinized at the earliest and with utmost expedition and promptitude. For the purpose, it is necessary to streamline the procedure for the issuance of social status certificates, their scrutiny, and their approval. So in that connection, my lord,
Mr. Chaudhary,
Yes, madam.
what is the law in this regard that the office certificate that so it is the mother's caste of is that the law?
Yes, my lord. Ramesh Bhai's case.
Can we have judgment?
Yes, my lord. My lord, the citation is 2012, 3 SCC 400.
Can you read out the relevant part?
Yes, my lord. I'm reading, my lord, para 53, 54, and 55.
Yes.
And operative is para 55. That's why I'm reading. In an intercaste marriage or marriage between a tribal or a non-tribal, there may be presumption that the child has the caste of the father. This presumption may be stronger in case where the intercaste marriage or marriages between a tribal and a non-tribal, the husband belongs to a forward class. And let me kindly have page 424.
Yes, please.
In an intercaste marriage or marriage between a tribal and a non-tribal, there may be presumption that the child has the caste of the father. This presumption may be stronger in case where in intercaste marriage or marriage between a tribal or a non-tribal, the husband belongs to a forward class. But by no means the presumption is conclusive or irrebuttable, and it is open to the child of such marriage to lead evidence to show that she was brought up by the mother who belonged to the scheduled caste, scheduled tribe. By virtue of being a son of a forward caste father, he did not have any advantages had in life, but on the contrary suffered deprivation, indignities, humilities, and handicap like any other members of the community to which his or her mother belonged.
That is what-
Additionally, that he was always treated as a member of community which her mother belonged, not only by that community, but by the people outside the community.
Precisely.
So this is the test, man.
That is precisely what the inquiry committee held,
Right.
that the girl was
And
brought up
most,
in the mother's community through all
exact-
through.
and most pertinently, my lord, subpara 7 of Madhuri Patil says, my lord, once the inquiry is in favor of the candidate at the
Candidate
end of
found
the
to be
matter.
genuine. Yes.
Yes. Paragraph 7, my lord, at page 255.
Yes, yes.
In case the report is in favor of the candidate
Yes.
and found to be genuine and true, no further action needs to be taken except where the report or the particulars given are procured or found to be false or fraudulently obtained. And in the later event, this same procedure as is envisaged in para 6 is to be followed. So, my lord, this is what precisely single judge has said, my lord. And in fact, my lord, the learned additional advocate general, Mr. Majumdar, who appeared in this case, he fairly considered that we didn't know, my lord. Only when the records were called for, it was he who revealed before the court that the vigilance inquiry is in favor of the candidate. In that situation, my lord, single judge has no other option. And secondly, my lord, all these facts have not been candidly disclosed. Let us not forget of suppression, my lord. Even non-disclosure by itself is enough to disentitle the equitable relief, my lord.
Sir, far as my opinion is that we have had judgments in Rajasthan
Yes,
wherein the matters pertaining to suspension of Sarpanch. The complainant claimed that it was on the basis of her complaint. And the division benches have disallowed impleadment applications, saying that ultimately the action impugned is by the state. So
exactly.
the complainant has no locus.
In
that
fact, my lord,
precisely-
we can draw the analogy that why in a service matter there is no public interest.
Precisely.
That's the line we can draw here also. my lord.
That's
Deeply obliged.
my lord, along with paragraph 7, your lordship will kindly read paragraph 15 also.
1(8).
1(5). paragraph 15.
Yes,
yes?
please.
May I read it?
Yes.
The question then is whether the approach adopted by the High Court in not elaborately considering the case is vitiated by an error of law. High Court is not a court of appeal to appreciate the evidence. The committee which is empowered to evaluate the evidence placed before it when records the finding of fact. It ought to prevail unless found vitiated by
This goes again.
judicial review of any high court, subject to limitations of interference with findings of fact.
How does this finding, this observation help you, sir? This is squarely in favor of the petitioner.
No, that committee has given it in our favor. Committee is the main authority, state committee.
Oh, very well.
Then the committee, the co-
That has not been appreciated by in your para 7. The observations made in para 7 are not diluted by the observations made. in
not
para-
diluted, no, your
please.
lordship would kindly see. Superior authority is that committee. Committee will act on the materials found by the inquiry committee.
Very well, sir. Anything else to say?
Then, my lord, your lordship would say, and let me read it complete. The committee which is empowered to evaluate the evidence placed before it when record a finding of fact, it ought to prevail unless found vitiated by judicial review of any high court, subject to limitation of interference with findings of fact. The committee, when considers all the material facts and record a finding, though another view as a court of appeal may be possible, it is not a ground to reverse the finding. The court has to see whether the committee considered all the relevant matters placed before it or has not applied its mind to relevant facts which have led to the committee ultimately record the finding. Each case must be considered in the backdrop of its own facts. Now, your lordship would.
Yes.
So inquiry committee report is to assist the
The only reason which has been assigned by the state level scrutiny committee for cancelling, for recommending cancellation is that the OBC certificate cannot be possessed only for the reason that the petitioner's father is a general category candidate. And that view apparently does not find favor as per the observations made in the judgment cited by learned counsel for the respondent, Ramesh Bhai. Then if two views are possible, then the appeal naturally we will not like to interfere, sir.
let me place this speaking order passed by the committee. Appeal memo page 78.
Yes, please.
Whereas a complaint received from the Anti-Corruption Liberation Union Jorhat, Assam, alleging that fake and fabricated other backward classes OBC certificates as coach community was obtained by Srimati Monsoon Borkatoki, whereas she belongs to Kolita community, which fall under general category. And on the basis of that caste certificate and Monsoon Borkatoki managed to clear the APSC combined computer examination in the order of the Land Revenue Service or grade 2000 under OBC reservation quota. Whereas on receipt of the complaint, it became needful for the state level scrutiny committee to verify the caste status of the Srimati Monsoon. The committee said several times and examined the evidence, documents submitted by the complainant and also heard Srimati Borkatoki. Whereas being the state level scrutiny committee, was held in 1811 at 1:30 p.m. and heard Monsoon Bharkakoti and perused her written statement submitted to the committee via their letter number so and so. The committee examined the written statements, documents, certificates as submitted by the Anti-Corruption Liberation Union, report submitted by the SPCD Assam, Guwahati, statement of Diganta Borua, Sarkari Gaungura, village headman of Sekoniora Gaon number 3, the town Moja, Jorhat East, and Revenue Circuit, and Sri Tarun Chandra Hazarika, village headman, Patani Akoti Gaon, Golaghat, and below mentioned facts and evidence as noticed. Sri Monsoon Bharkakoti, daughter of Dr. Shantanu Bharkakoti, resident of Club Road, Jorhat, Assam, was issued under backward caste PC certificate Puch community, countersigned by the extra assistant commissioner, care of deputy commissioner Jorhat dated 20. The complainant has stated that the Dr. Shantanu Bharkakoti, father of Srimati Monsoon Bharkakoti, presently working as SDMO under general category, as per her official record. The committee examined the provisional gradation list issued by Health and Family Welfare Department, might be dated so and so. The complainant has stated that Dr. Shantanu Bharkakoti, father of Srimati Monsoon Bharkakoti, presently working as SDMO under general category. As per the official record, the committee examined provisional gradation list issued by Health and Family Welfare Department as communicated by the Principal Secretary of Government Officer, Health and Family Welfare Department, hide letter number so and so. The ancestral home of Dr. Shantanu Bharkakoti is at village Betonil Akoti, Gaon, PO, Betoni district, Golaghat, Assam. Sri Tarun Chandra Hazarika, village headman of Betoni Akoti, Gaon, has stated in his letter addressed to the police inspector CID that the great grandfather of Dr. Shantanu Bharkakoti was late Jagannath Kakoti, who shifted his residence to Guwahati. His son was late Shivanath Kakoti, and his son is Dr. Shantanu Bharkakoti, and Srimati Monsoon Bharkakoti is the daughter of Shantanu Bharkakoti. Late Jagannath Kakoti's brother was Pushpak Kakoti's family, still resides at Betoni Kakoti Gaon, and by their own admission, they belong to Kalita community. The complainant has submitted BTech admission waiting list women so and so Meghna Bharkakoti in the open general list. Cousin of petitioner. The committee SLC has also heard Srimati Monsoon Bharkakoti in its hearing held on such. She has also submitted a written statement wherein she mentioned that her father or Shantanu The committee SLC has also heard Srimati Monsoon Bharkakoti in its hearing held on such. She has also submitted in a written statement wherein he mentioned that her father Shantanu Bharkakoti belongs to general category, Kalita, and her mother Srimati Purnima Dutt Bharkakoti belongs to Koch community. In her written statement, Srimati Monsoon Bharkakoti has stated that her mother has been living in her paternal home after marriage. In a written statement, Srimati Monsoon Bharkakoti has stated that her mother has been living in her general home after marriage. With Santanu Borgade at their marriage was an intercaste marriage. So the parents of Dr. Santanu Borgade did. So the parents of Dr. Santanu Borgade did not accept her as their daughter-in-law. Further, she stated that the Srimati Monsoon Borgade was born on 12/4/1990 in the parental home of mother and Srimati Purnima Dutt Borgade. Srimati Monsoon Borgade stated that as she was born and brought up in the paternal home of her mother, who belongs to Koch community and largely accustomed with the customs of Koch community, hence she has adopted the religious act and Koch community and totally accustomed with the culture of the Koch community. She mentioned that the caste certificate was issued from the Office of the Other Backward Classes in the year 2006. The SLC carefully examined all those mentioned facts and documents and examined the guidelines issued by the caste status of offsprings of intercaste marriage and also referred to various judgments of Honorable Supreme Court regarding the caste status of these things of caste marriage between tribal and non-tribal SC and non-SC and OBC and non-OBC made following the advertisement. Santanu Borgade, father of Srimati Monsoon Borgade, belongs to general category. Dr. Santanu Borgade is a medical doctor appointed to class 1 cadre of health and family welfare as per graduation list issued by the Health and Family Welfare Department. As per graduation list issued by Health and Welfare dated so and so, Santanu Hazarika belongs
Comment
to
council. Just hold on. Come to page 83, para 7 of the report.
Yes, Mr. Dhar.
Aye.
My lord is that.
Come to para 7. However, during inquiry, it has been found that she and her mother were never abandoned by her father. Her father, Dr. Santanu Borgade, has been working in the Health and Family Welfare Department and posted mostly in adjacent districts of Golaghat and Jorhat. Her mother is also a government employee of Irrigation Department, Jorhat. Can we get her service record? What caste she has given out there? That would be clinching. Get that service record. Yes, yes, definitely. So her mother did not have the certificate.
Yes.
But the girl had the certificate in 2006. Could she have anticipated that I'll use this certificate to procure a government job?
In 2019.
So let us get the service record of the mother. That
My
will
lord,
be,
my only one submission, my lord.
yes, please.
At the moment the vigilance inquiry is in favor of the.
Why are you
Either way, I'm
apprehensive?
just saying, my lord. Then, my lord, the committee had no jurisdiction to go into the matter. Therefore, my learned friend is reading the
We'll
report.
see, we'll see.
My lord.
Why are you so apprehensive about
No,
this
no, no, my lord, not at all.
inquiry?
No, no.
This seems to have escaped notice of everyone.
Yes, maybe.
Learned Government Council shall procure the service record of Srimati. What is the good name of the mother? So and so, mother of the respondent head petitioner from the Irrigation Department.
It's a fact, my lord, she obtained the certificate in 2019.
Maybe. What has she mentioned in her service record when she got employed? That is something which has to be seen. In the background of the fact that the certificate was procured as late as in 2019, after this issue cropped up.
Yes.
On 28.
Diploma.
Item number 1 of daily list orders.
I have been taken up.
May I please, Your Honor?
At 10:30. And there were two matters at 25. Yes.
This is come for orders to the lordship. So
Just a minute, you've given item number 1. You've followed up which matter?
25,
You've followed up.
you could have completed the supplementary list.
So this PI lordship I have filed mainly against the Northeastern Electrical Power Corporation, my lord. When, my lord, in the year 2000, my lord, my lord, they have caused a havoc by releasing huge amount of water from their power project situated in the state of Nagaland. So they have caused immense loss to the properties and the livestock and destroyed and which are destroyed and washed away in the flash flood that has been caused by the sudden release of water from this dam, my lord, at the evening hours of 26th, my lord.
25 को. What has happened in compliance of directions given on 25th January, sir?
My lord, we have the instruction. We had 2 sittings. Because the only question is now, can this be prevented?
Mhm.
And
Not only prevented, whether they are required to be compensated.
so that, yes, that is also, that question also comes. But here in this case, the issue is, the matter rather was sent to the district judge Golaghat for an inquiry.
Yes.
And district judge Golaghat held that we have been sending warning as per decision taken on 17/5/2018. Right from 21/7, we released water on 27/7/2018. And right from 21, we have been warning the state to take necessary precautions.
Mhm.
And those screenshot of WhatsApp are there on record, and it is admitted. And if your lordship permit me, I'll just take one paragraph of the finding of the learned district judge.
No, that's
That's
okay,
okay,
we understand, sir, we understand.
Yes.
But as a consequence of the water being released,
It is
The
not only
persons
that.
are-
No, it is not. It is not that. My lord, there the total catchment area is 8,100 square kilometers. Out of which Doyang hydroelectric project, it intercepts only 2,600 and odd square kilometer.
Mhm.
The rest, 5,000 something of the catchment area, there is a free fall.
okay,
And my lord, Golaghat is prone to flood. Even this year, there has been flood. But we have not opened the radial gate because we have a reservoir which has the capacity of 324 meters.
Hmm.
Now, once it reaches 324 meters,
Mhm.
we will have to release the water. So every year, on the onset of monsoon, there is a meeting between the district disaster management and the NEPCO authority. And decision is that please give us early warning when you release.
Mhm.
When the matter came up on 21st of January before the before the court, my lord, the lordship asked me, can you retain water beyond 324? I said that is our optimum capacity. We have made a statement in paragraph 20 of our affidavit in our position that we cannot retain the water. And it is, my lord, the NEPCO was established in 2000, commission rather in 2000.
Okay.
And the first, this problem arose, the flooding, in 2018 because of the incessant rain.
so the continuous generation of hydropower is taking place since
Yes,
2000.
2000. And only in 2018, if your lordship hear me fully,
No, we'll hear you, no difficulty at all.
I know, but at the moment, my lord, the order dated 25/1, what I'm saying is we have got the instruction.
You
We'll
file it
release
on
it,
affidavit.
file an affidavit.
File an affidavit.
And my lord, since the people have to come from outside, if your lordship can give us 2 weeks time before that, we will try to file it next week, but your lordship will pick it up after.
What do you say? Senior counsel. Shri, appearing for the respondent, NEPCO, submit that the affidavit in terms of directions given on 25/1/2023 would be filed within next 2 weeks. Re-notify on. Can have it on 15 parts.
Let me have. No, it will come up for hearing or it will lordship. will
Let
dispose
the
it of-
affidavit come, then we'll see.
All right.
Item number 25 of supplementary list.
May it please your lordship. May it please your lordship. This is in matrimonial appeal lordship. It was already admitted and notice was issued to pro forma respondent lordship. And service report is awaited as per office note dated 22/2020.
The respondent is represented.
I appear for the
respondent number one, why?
Why?
I
So
have
let the
some
appeal is admitted, we'll post it for hearing then. A record is may be called,
record already received, lordship.
already received, then it will go for hearing.
Lordship.
may kindly fix an early date.
Okay, the service is complete, record has been received. The
Lordship,
appeal has been admitted, service is complete.
service is awaited on pro forma respondent. Lordship. Number
Service
two.
on the contesting respondent number 1 is complete. The respondent number 2 is a pro forma respondent and the service upon such respondent is waived. Record has been received, list for hearing.
May kindly fix an early.
What is the IEA for?
IA was
for
for
the
stay of the impugned judgment, lordship. On that day, while issuing notices, said that the stay will be considered on next date, your
What
lordship.
do you say about the stay application?
I
What is
have
your
di-
different-
I have
Lordship?
divorced the wife, lordship, wife initiated the proceeding, that the divorce proceeding. Nama will be declared as
Lordship,
null and void, that
There
was.
is absolutely no ground for this appeal. Lordship, therefore, I am praying for an early date of hearing so that the matter may be decided once and
Okay,
for all.
why, how do you say, or what is the ground? To
Ground-
submit that there is no
ground
merit in
being-
the appeal.
ground being that, here in this case, talaq was registered on mere asking. On 12/5/2012, the appellant husband went to the respondent number 2, Qazi, with an application saying that I want to divorce my wife. And accordingly, on the same day, talaqnama was registered.
Hmm.
That my lord is
The judgment under challenge dismisses your divorce petition.
Lordship,
no.
in his favor, lordship.
judgment
The
is in my favor.
judgment was in favor of
Okay,
the
it
wife.
is
lordship.
declared.
Yes,
Declared null and
talaqnama has
void.
been declared to be null and void.
So I am praying to stay of that impugned judgment and declare lordship. So that lordship, my talak will remain, lordship.
And the wife has been litigating for more than 10 years now. Lord.
We'll hear you finally.
Yes.
No ground is made out. to Stay the impugned judgment, thus the interlocutory application number so and so is disposed of. List the appeal for hearing in May.
Lordship. Obliged.
Item number 2 and 3 of daily list for hearing.
Please, your lordship. Your lordship, both the matter have become infructuous, your lordship.
As stated by counsel, then counsel she so and so. The instant. Writ petition is, both the writ petitions are disposed of as having rendered infructuous by subsequent events. Mark the attendance of all counsel.
Item number 4 and 5.
May I please, your lordship. This two matter has also.
Bench nahi, but now there is bench.
May I please, your lordship. This two matter has also become
Infructuous as stated by counsel for the petitioner, both the writ petitions are disposed of as having rendered infructuous by subsequent events.
Item number 6.
Just ask him. कल इतना दूर से बोले था ना ये तो- Who's for the appellant,
My lord,
Petitioner?
I have appeared for item number 6 with analogous case, being a senior panel counsel of central government for the analogous case. But the first case, my lord, that is represented by Jadov Dole, another senior panel counsel. Whether he's I could not contact with him. I was also out of station, my lord, due to some on medical ground. And the matter may be taken.
Yesterday, sir, there was a clamor from the bar members that the hearing matters are not being taken up. Today, every matter will be called out. Let us
Yes, my
see.
lord, actually, I can
Where is
place
Mr.
I can
Chaudhary?
place my argument. for
Can we
second-
request
second
Mr.
part, but
Chaudhary to be here?
Petitioner is also not. He is also not available. Regarding some Assam Rifles Act, regarding they have
Present
challenged.
for the petitioner. List up to 2 weeks. 4 weeks, sorry, 4 weeks. List for hearing after 4 weeks.
My lord, my one problem
Yes,
is
please.
there, my lord,
Please,
actually,
thank you, sir.
what happened, actually,
Yeah.
my lord, due to some,
See that I'm not dependent on. Assigned to someone. else. You want. Why is he bothered about? They are not passing any adverse order. Why are you worried?
I'll go for treatment, Lucknow on 4th of March. Some medical ground, my lord, that's why before 4th,
It will not be taken up on 4th March. We have posted it after 4 weeks. Don't worry.
yes, my lord.
Item number 8.
What is the?
Is there any live issue here?
I don't know. I have,
Distributorship.
I've been instructed by my junior. Apparently, there is some discussion going on about some kind of a compromise. But we don't have anything in writing, so I have otherwise come prepared for a hearing.
Even we have also the same instructor, same knowledge about that, because that some amicable settlement is going on. To matter, maybe fix.
Change of site of LPG distributorship. It must already been commissioned long back.
It was
So what's
commissioned
the-
that has been interfered with by the Lawrence Single.
By Leonard Single Judge. Oh,
They have come up against that.
okay. So is there a stay?
No.
There is a stay, sir. Stay was passed on 2/5/16.
I'm sorry, but yes.
Lordship may be pleased to pass over the matter for timing, Lordship. Mr. Kane Chaudhary will appear in this matter. Lordship. If in any case, Lordship, if thinks that is not.
A request is made by counsel on behalf of the petitioners to adjourn the matter. List up 3 weeks.
Much of
Petitioner कर दीजिए. Appellant कर दीजिए. Writ appellant.
Apple.
Item number 9.
Time no.
The deliberations are over.
Lordship, it relates to non-payment of HRA for the period from 25/9/2007 to 13/7/2009. Subsequently, he was paid the HRA, Lordship.
So now infructuous.
No,
No, Lordship.
Then
my lord, this petition was allowed and the direction was given to pay the HRA. Now we filed a review against that, and the review was allowed on, my lord, 1/12/2022.
1/12/22.
Yes, last year. And my lord, during the pendency of the review, your pursuant to the direction of this honorable court, we released the pending HRA, but that is subject to outcome of the present writ petition. What we will have a look at the review order. It is part of the record, which is marked as
Review before tribunal.
no, my lord. Tribunal rejected his prayer, and on an appeal, this present writ petition was allowed by the division bench of.
So this is a review petition basically.
No, my lord. Review was allowed by order dated 1/12/2022, my lord. Which is the review order is marked as document X in the file, my.
And this WBC was restored.
And the WPC was restored.
Okay. So now
And-
this is a restored writ petition.
Restored WPC, which has come for hearing.
Oh.
And in the meantime, we had paid the order because during the pendency of the review petition. And while disposing of the review petition, your lordship was pleased to,
Review order any.
Where is the review order?
my lord, it is, I have checked the record, it is marked as document X in the file, my lord. There is a note with perhaps my lord's file is there, my lord. It is not there. There's an office note. And the review was allowed by my lord Justice Sham and my lord Justice Tagia.
So are we prepared for hearing?
Lordship may hear it, but the record will be necessary because
What record?
because their contention
The
is that
original application, you have annexed the application and the judgment, all documents filed before the tribunal are here. What kind of record do we need?
Lordship, their contention was that 15 similarly, our contention was that 15 similarly situated persons were given HRA for the period of time, Lordship. Their contention was that since they belong to different division, Lordship, different rules will apply for them, Lordship. In the review itself, that was recorded, Lordship. And my contention is that the zone is same, Lordship, and the railways are same, so same yardstick will apply in this case itself, Lordship. So in the record on the earlier occasion when the WBC was taken up, Lordship, they were not able to show that those incumbents were differently situated, Lordship, and that at that point of time, Lordship, type 4 quarters were remaining vacant. And
So this argument did you not raise when the review was being heard?
unfortunately, Lordship, on that day, my senior Lordship, Yupen Iyer, he was not there, Lordship, and he was not prepared, Lordship, probably.
So is there an affidavit with the name of the employees you are saying who have been granted HRA just like the writ petitioner?
It's there, Lordship.
Where is that ground? That must have been a ground before the tribunal.
Before the
Let us see.
before the trial,
You are on parity. Where is the pleading, please?
Lordship, I'm
Are you preparing the file while standing on the dais?
no, Lordship, it's there, Lordship. I'm just page 38, Lordship.
38. Grant of house rent allowance, annexure 7.
Point number 1, Lordship. In the Lordship,
Oh.
the bottom part, Lordship.
You want to contend that employees at par with your petitioner, they were granted HRA. There has to be a pleading. Where is that pleading?
Lordship.
Seems you are not
At
prepared, sir.
Page 10, Lordship.
10.
Yes, Lordship. Page 6, paragraph 10, Lordship.
Page 6 of what?
Of this writ petition, Lordship.
Page 6, para 10. Well, whether that was the ground before tribunal,
Yes, yes.
you
Lordship.
can't be allowed to take the ground in writ petition.
It was there, Lordship. I'm just pointing.
A new ground. Yes, petitioner also pleaded and argued. So there is only, you are claiming parity with only one person.
Yes, Lordship, but then the list furnished by the railways in the RTI, it contains 15 names. This particular person, Lordship, belong to our division itself. And rest of the persons belong to other
Different division.
division.
What is their response to this contention in the tribunal?
They say that, Lordship, although they allowed me HRA from a later date.
Later date.
Later date, they say that on that day when they allowed it, the type 4 quarter which was lying vacant was occupied. Means there was no vacancy after that date. Lordship.
So that is why you were granted HRA.
Yes, Lordship.
You had to live in your own house.
Yes, Lord.
Then
Lordship, Lordship, my contention was that the quarters which were there lying vacant.
he vacated the house. If they are vacant, they have to. Okay. There's no. Okay. Right.
Mr. Sharma, are you prepared to argue the matter? We are
Lordship,
taking
my
it up for
senior-
disposal today.
My senior will argue, Lordship.
Where is Mr. Nayak?
He is in Lakes in code number 19, Lordship.
This is the first court, matter.
I'm sorry, Lordship, but then he was supposed to come here, Lordship, after item 1. That
It can't be done like this.
took some time, Lordship.
So what is your answer to this? They are
Look,
saying
look.
that in your category, quarters are lying vacant, whereas in case of the others, there were no vacant quarters. That hence the difference here. What is your answer to that? They say that this aspect of the matter was not pointed out, could not be pointed out earlier, because you have not implemented the correct division who is supervising this matter. These are the two issues here. Review was allowed by taking note of this submission and considering that this has financial bearing. We thought the matter should be reviewed.
No.
But the payment made was not disturbed until directed otherwise. You have to now tell us whether these are on factual count correct or not, where are the pleadings, point it out. You can satisfy the court, fine,
Lordship,
otherwise.
Lordship, in the review petition, I have filed an affidavit, Lordship. In that affidavit, I have answered.
No,
to-
review is gone. Now we are hearing the read petition. of
Lordship,
them.
that's what I may be allowed to bring those on record in this case. Lordship. Or the records of the review petition may kindly be called for, Lordship. Because there I have
But
categories.
please don't do it. This is the first court.
I'm sorry,
and
Lordship,
My
but
lord
then-
is taking so much effort to dispose of pending matters. Merely for asking, don't go for these adjournments.
No, Lordship, therein, that issue was dealt with in the affidavit. Lordship.
Are you prepared to argue it finally today or not? If you're prepared, then you argue.
I'm sorry, Lordship, my senior will agree.
Hearing.
May I pray, my lord, the records of the review may be tagged because the explanation is given in the review so that we can explain your lordship, the review application number 9 of my lord. 9 of 2019. Yes, okay. Good.
Yes,
My lord, whether your lordship has fixed any date in this matter.
After craving. Please, Lord.
Matter number 10.
Your lordship, before the petitioner size begins, your lordship, I have a small prayer, your lordship. I apologize, your lordship, Mr. P.K. Tiwari, senior advocate, who is appearing for the private respondent, 5 and 6, your lordship. What has happened, your lordship, the advocates on record for respondent number 5 and 6. Both one has left the profession altogether, your lordship, and the another has shifted from here to home villa, your lordship. And
This is the
since
High Court
my senior's name is also not reflected there, we are not aware of this matter. Your lordship.
Yes.
We pray for a small accommodation, your lordship. If it can be listed next week, we'll be ready and we'll do the matter.
This is the Arunachal-
Arunachal.
this is the Arunachal
It
matter.
doesn't matter.
Yeah.
But what happens here, 2016 matter, I think.
My lord, this is a matter pertaining to selection of grades, incumbents to the Arunachal Pradesh Judicial Service Grade 1. The petitioner secured the highest mark. Lordship will kindly turn to the last.
Look, Mr.
My
Patwari,
lord,
2016, it was about 7 years back.
my lord.
What is the live issue today?
My lord, live issue that I have not been selected on my lord ground, which is not, my lord, legally untenable ground. I have not been selected, though I secured the highest mark. My lord.
Posts have been filled up.
Post have been filled up, we have made them party and they are representing the private.
That is why the private.
The petitioner secured 91.83% mark and the selected candidates secured 188.
All right, when will you be able to complete your instructions?
A lot of them fix it on next Thursday. Will
Your name please?
AR Gogoi, your lordship. My name is not on the record. I am appearing from Mr. P.K. Tiwari.
One, two, and three.
This is David. Important. Your turn. No. That is the later. Now recent. List on.
Thursday, your lord. Next Thursday, your lordship. On
Second March.
second, lordship, small pair, lordship. Mr. Tiwari's name may be reflected in the first picture.
Name of
Senior counsel's name. to be-
seniors. Name of senior counsel is not supposed to be reflected.
In that matter, then, okay.
Matter numbers 11 to 15.
Food corporation.
May it please your lordships. Lordship, in item number 12 and 13, my lord, our names are shown, my senior, Mr. A.K. Bhuya, my lord, we are not appearing in this matter. Lordship, only item 12 and 13, my lord.
Will
Lordship,
you argue item number 12 and 13? The others will follow suit.
Lordship, we are no more appearing, my lord. The brief has been.
Which are the matters in which you shall be appearing?
Other, none, my lord.
You must be appearing in the remaining matters or what?
No, my lord.
No.
No.
Presently, you are representing in all these matters.
Lordship, in 14 and 15, senior counsel Mr. K.N. Sir will appear, lordship.
Where is he?
He is on leg, lordship.
That's
But
excuse.
can it be taken up after some time?
Very well. We'll pass it over.
Lordship.
Pass over.
Matter number 16.
None present. Hey, what is it? Oh. क्या करें? No one is come. None present पर की name it. None present for the petitioners re-notify in month of May. Appellant. Why she's will mark your attendance.
H current. Wait. Next. S Purva or
6.
S Chutia.
Item number 18,
Let my sneer.
That's right. Not there.
Might be a lot. And this appeal is by the state against the judgment passed by one single judge, whereby the notification constituting a wildlife sanctuary was set aside. Of course, the liberty was granted to start the process afresh, but the grounds on which the and particularly the at the instance of the petitioner, who according to my submission, my lord, has not locus. Primarily, the honorable single judges said that there was no proper publication of the initial notification. And my lord, the writ petitioners do not have any right over the land. Admittedly, they say that they were earlier fishing for some time pursuant to some fishery lease granted. So they do not have any personal right as such over the land. They had a commercial interest. So, and it is not a public interest litigation on behalf of some others who were, if at all, fishing in the bill.
If the notification is not in accordance with law,
My lord.
then you have been given the opportunity
In
to
my
issue a fresh one.
true, my lord, but my humble submission before lordship is notification is in accordance with law.
Okay, very good. Demonstrate, please.
My lord.
Let us see the findings of the other side is ready.
Yeah.
Okay, please read out the findings.
My lord. Lord will find the judgment passed by the honorable single judge at page 263 of the memo of appeal.
Yes.
It's slightly longish judgment. My lord. From 265 onwards, paragraph 2 onwards, I am reading.
Paragraph 2.
My lord. Onwards. At page 265. Man, the petitioner number 1 is a registered society constituted by actual fishermen who reside in the revenue villages in the vicinity of Deepor Bill, the large water body. In the Ramsarani Moja of Polakbari circle of Kamrup rural district, the challenge here is to the notification dated 21/2/2009, whereby 4.1 square kilometer area of water body is notified as the Deepor Bill Wildlife Sanctuary under the Wildlife Protection Act 1972. The declaration became operational with effect from 25/2/2009 when it was published in the Official Gazette. The petitioners claim traditional fishing rights in the Deepor Bill, and they contend that the government is obliged to protect their economic rights and arrange for rehabilitation of the fishermen whose livelihood will be impacted by the impugn notification, whereby the water body is declared to be a protected sanctuary.
Mr. So-and-so Land Senior Council submits that notification issued on 12/1/1989 under section 18 of the 1972 Act, which declares the government intention to constitute the Deeporville into a wildlife sanctuary, was rescinded midway on 29/5/2002, and accordingly it is argued that without a fresh section 18 notification, the declaration of wildlife sanctuary on the basis of the old declaration made on 12/1/1989 is legally invalid. Wildlife Act 1970. The Senior Council refers to Collector's Order of 7/1/1994, where the objection of the petitioner and the others, including the Assam Fishery Development Corporation, were noted, and the extinguishment of livelihood of the fishermen were taken into account, and it was opined that the declaration of the sanctuary should be deferred until alternative means of livelihood for the fishermen is ensured. On this basis, the council argues that the rehabilitation measures must precede the declaration of sanctuary. For the petitioner, the Senior Council highlights the need for balancing the interest of the livelihood of the fishermen, the protection of the area, which is an ideal habitat for the birds, and the specific observations in the rescindment order passed by the government on 29/5/2002, which noted the positive efforts of the fishermen to protect the bird of Deeporville. To argue that this quasi-judicial order of the Principal Secretary Forest Department could not have been cryptically reviewed. The absence of reason in the change of the rescinding decision taken by the government on 29/5/2002 is also pressed into service by so-and-so to argue that the turnaround decision without any supporting justification cannot be legally sustained. Referring to the requirement of proclamation under Section 21 to be published in the neighborhood of the declared area, the Senior Council submits that such a proclamation was never published in the neighboring area, and it is further argued that the publication of the proclamation in the newspapers is not adequate compliance of the statutory requirement. Thus, it is contended that the concern of the affected group has not been addressed by the state. The failure of the collector to undertake the examination of the existing claims under subsection B of Section 22 is projected by the petitioner as a serious infirmity in declaration of the Deeporville as a wildlife sanctuary. Respondents' arguments. On the other hand, so-and-so additional AG respondent submits that the petitioners never exercised any traditional fishing rights in Deeporville. He further submits that fishing for a few years was allowed on the basis of lease granted by the AFDC. However, the 7-year lease granted on 1997 was terminated on 29/11/1999. And since then, and or even before the lease, the petitioners had never exercised any fishing rights, including the traditional fishing rights in Deeporville. The learned additional AG projects that the total area of Deeporville is over 10.1 square kilometer, whereas the notified sanctuary covers the core area of 4.1 square kilometer, and under the impugned notification of 21/2/2009, the protection is intended for the core sanctuary area under the 1972 Act, and therefore the government side argues that normal activities in the remaining area of the water body can continue without being impacted by the declaration of sanctuary. Mr. So-and-so refers to the step taken under Section 18 of the 1972 Act, the appointment of collector under Section 19 thereof, and the proclamation made under Section 21, whereby objections were invited through newspaper advertisements dated 31/5/2006. On these facts, the council submits that petitioners had adequate notice of the intent of the government for declaration of a portion of the Deeporville as wildlife sanctuary, and yet petitioners failed to raise their objections, if any, by responding to the notices published in the newspaper on 31/5/2006. He submits further that the two newspapers are widely circulated, and therefore it should be treated as due notice in furtherance of the statutory requirement. The government council submits that the provision of 1972 Act must be interpreted to advance the objective of the statute, and the procedural requirements prescribed under Section 18, 21, 22 cannot be conceived to defeat the very object of the Act, and the attempt of court must be to do substantial justice. Therefore, Mr. Saikia argues that since the petitioner's right was limited and was subsisting only during the lease period and did not extend after termination of lease dated 29/11/99, petitioners, having realized the weakness of their position, deliberately avoided giving any response to the newspaper advertisement. Thus, it is submitted by the Additional AG that the current challenge of the petitioner should not be entertained. He also contends that vicinity of the Deeper Bill is fast developing as it is now within the city limits, and in reality, there is no family in the area who are dependent on fishing. Referring to the exalted status of the Deeper Bill, which is identified as one of the 26 Ramsar Convention sites under the Wetlands Conservation and Management Rules 2010, Mr. Sekas emphasizes that the Deeper Bill is now to be treated as a wetland of international importance. The learned additional AG argues that restrictions imposed by 2010 rules will automatically apply to the protected water body and none can claim any fishing rights in the protected area. Alluding to the fact that Wetland Conservation and Management Rules 2017 has now replaced the 2010 wetland rules and focusing on Rule 4, which severely restricts the activities in the protected wetland of the state. Council argues that fishing rights claimed by the petitioners cannot be entertained on account of the wetland rules. The council refers to suo motu registration of a PIL number 3 of 2017 by the High Court in pursuance of the direction of the Honorable Supreme Court issued on 3/4/2017 in WTC number 230/2001 project that the Ramsar Convention sites are matters of international heritage and therefore this court as the jurisdictional high court for the Deeper Bill must not allow anything which would endanger the protected wetland. The Wildlife Protection Act 1972. The object of the act was to provide
Para 14.
para 14, my lord. Yes, these are the discussion, my lord. The most significant facet of the first process is the earlier recommendation made by the collector on 7/1/1994 to defer the sanctuary declaration and to explore alternative livelihood for the fishermen. The consequential decision of the government to rescind 12/1/1989 notification under Speaking Order 29/5/2002 is also ambiguous. Yet these well-reasoned decisions were reviewed in the second process without indicating any ground for the change of 10. More importantly, when the collector stated that no objection or claim were received, there was no reference to the pending claims of the petitioners and they already made declaration in their favor, noted earlier by the same officer, that is the collector, on 7/1/1994. The decision taken by the collector and the government in the earlier round were quasi-judicial in nature in the context of 1972 Act, and those decisions of 7/1/94 and 29/5/2002 were supported by well-articulated reasons. The collector and the departmental commissioner formed their opinion and voiced their concern with reference to the materials from record. Such well-reasoned, well-considered decisions cannot be reviewed without a similar exercise by application of mind to all relevant parameters. Moreover, it is illogical for the collector to say that none had put forward any claim in pursuance of the newspaper advertisement of 31/5/2006, since the inquiry by the collector envisaged under Section 22 also required him to determine the existence of rights has to be ascertained from the government records. When the collector and the principal secretary in the earlier round had already declared their rights in favor of the petitioners, the mere absence of fresh objection does not permit the collector to revert from his earlier view without disclosing why opposite view is taken by him on the second occasion. It was earlier opined by the collector in his order dated 7/1/1994 that alternative livelihood for the fishermen in the vicinity of the Deeper Bill will have to be provided, and on that basis, the government on 29/5/2002 had decided to rescind the earlier notification. Therefore, the fishing and livelihood rights claimed by the petitioners cannot be brushed aside simply because the petitioners did not raise.
We are just interrupting you.
My lord,
How would you escape the rigor of 25A, please?
I couldn't follow it.
How would you escape the rigor of 25A? Please read section 25A.
Section 25A of the Act.
Conclusion within 2 years.
Time limit for completion of acquisition proceedings. The collector shall, as far as possible, complete the proceedings under Section 19 to 25 within a period of 2 years from the date of notification of declaration of sanctuary under Section 18. The notification shall not lapse if, for any reasons, proceedings are not completed within a period of 2 years. My lord will kindly note, Section 25A deals with the time limit for completion of acquisition proceedings. My lord, this Section 25A will come into play only when it is found that the area which is sought to be constituted as a wildlife sanctuary also covers an area where persons are there having settlement over the land.
Okay.
Then the land will have to be acquired. And that acquisition proceeding has to be completed within 2 years. Here is a case, the petitioner is a my lord, some association.
Exercising fishing right, that's all.
Absolutely, my lord. They have
Nothing
got,
beyond that.
admittedly, they have got no right over the land.
Right.
That being the position, my lord, I am arguing, the first point that I am arguing is they have got no locus to file this petition and challenge the notification. First, they will have to establish what is the locus they have. If your lordship goes to the provisions of section 18 and the subsequent proceedings which provide for, my lord, giving them prior publication and giving them opportunity of hearing, it says if the determination is to be made for the determination of the rights of the persons over the land.
Issue is that you have reviewed your own decision.
My lord,
And in the earlier decision, they were heard. Their rights were recognized.
my lord,
The opinion of the collector was
my lord,
that yes, they have been carrying out fishing activities since long. It is their livelihood which is being affected. So if you wanted to review the decision
my lord,
after a gap of almost 5 years,
Right.
why not a fresh notification? Why
Madam,
review?
my lord, fresh hearing was done. My lord, my first submission before lordship, subject to your lordship's consideration is, my lord.
Yes.
Who is the petitioner before lordship, my lord? The petitioner is an association of fishermen, according to them, who had only exercised fishing pursuant to a lease, and they paid kiss
No,
money.
That is not the finding of the learned single judge.
My lord,
The learned single judge says that these are not persons who are carrying out fishing activities as a consequence of lease being granted. They are local persons who are surviving on that.
my lord, kindly see who is the petitioner, read petitioner. Read petitioner is the association who is only formed by fishermen, and this association has only one right, that is the right under the lease. No individual has come before your lordship, my lord.
Any lease of any of the members of the association has been placed on record.
No, my lord.
Then how do you say that they have been carrying out fishing activities by virtue of a lease?
I'm sorry, my lord. Yes, there is a lease, the lease was there, lease was cancelled. And the petitioner, my lord, petitioner nowhere says in the writ petition that they individually exercise any fishing right. They are not claiming that they have got any right over the land. They are only saying that traditional fishing, the act doesn't recognize any traditional right. Act only says a person who have got right over the land which is sought to be converted into a sanctuary will have some right for compensation, etc. Nothing else. Lordship, if your lordship permits at this stage itself to take to the relevant provision, lordship may kindly see section 19 first, my lord. 19 is the relevant section, my lord. After initial notification of section 18, it is the procedure.
Para 18 of the impugned judgment.
My lord. The fishing rights claimed by the petitioners, in my understanding, is not relatable to the lease granted to the petitioners by the AFDC. And I'm challenging this finding. This
What is the basis?
basis is, my lord, how can they have a my lord right? Lordship may kindly say what right is recognized under the act which will be taken into consideration. Section 19, my lord.
Yes.
If your lordship so permits, my lord. Section 19 says when a notification has been issued under section 18, the controller should be collector, my lord. Collector shall inquire into and determine the existence, nature, and extent of rights of any person in or over the land comprised within the limits of the sanctuary. You do not have right over the land. A person, my lord, lordship will kindly visualize one thing. This is an area, the entire India possibly is, we say in the judgment it is recorded, possibly submissions are made from our side, around 10 kilometer area. The entire wetland is 10 kilometers square, 10 square kilometer. Actually, it will be around 20 square kilometer. Now, out of that, my lord, the core area of 4.1 square kilometer is only sought to be made a wildlife sanctuary. Now, the entire wetland itself is a government land, my lord. Lordship will kindly see. This
No dispute about that. There is no dispute.
Now, out of that, if any core area within that 20 square kilometer is sought to be converted, a person who is saying that I have got a traditional right, the act doesn't recognize any traditional right, my lord. And they, although they are using the expression traditional right for the purpose of building up a case before your lordship, actually they were only a lessee under the lease granted to them, my lord. So they have got absolutely commercial
How do you
interest.
substantiate this argument?
My lord,
This is a material bearing on the controversy.
My
How do you substantiate this?
My lord, I'm showing the documents annexed in here that there was a lease and they failed to pay the.
Any of the members of the petitioner association? Particular lease of any member of the association?
My lord, here under the settlement rules, the lease is granted to an association of fishermen who are 100% fishermen. There is an association, they are granted.
Mhm.
So accordingly, when in pursuance of that rules of 1977,
Whether
they were granted
the lease was granted to the petitioner association?
association.
Is there any pleading? to
Yes,
this
yes.
effect?
My lord, there are documents to show.
Let's see.
My lord. Lordship, I will be referring to these pages.
Just 1 minute.
Yeah.
Yes. Yeah.
My lord, may I kindly turn to page 80 of the memo paper. Well, may I hand over this list of days where I have given the date?
80.
80. ma'am. This is the document, my lord, a letter issued by the Assam Fisheries Development Corporation Limited. They have issued the letter to the secretary of the petitioner association, my lord.
Oh.
Cancellation of settlement due to non-payment of installments. Due to non-payment of second and third installment of the dues from 1999 to 2000 in time. Under the provisions of section 2, 4 and 4 of the agreement, the settlement of your Samiti is in respect of bill is hereby declared null and void under the provisions of section 3 of the agreement, and the possession of fishery is hereby taken back from your Samiti. Legal actions will be taken up in due course of time for realization of the area dues. Now, in addition to that manner, page 82 is the representation by them, petitioner manner, for settlement of fishery again, in the name of the association. And Lordship will kindly turn to page 85 is another representation of 13 July. There, in the first paragraph itself, they have narrated what is their status. That the petitioners are the members of the Deepor Bill so mean Samobai Samiti Limited. It is a registered cooperative society comprising of members of actual fishermen solely dependent on fishing and fish business. So, madam, they have a commercial interest. Madam, other than this, they do not claim to have any right. So, madam, my second submission will be ultimately the procedural safeguards that is provided by the Act for publication and giving them opportunity to the affected person. This opportunity, even if given to them, will be an useless formality, as the Honorable Supreme Court says, my lord. Even if it is given to them, what will they say? They cannot say that I have got a right over the land. They are not saying till today, even in the writ petition, my lord.
They could not have been. They only claim that their livelihood is provided by these body.
My lord, my submission before Lordship will be when there is a commercial interest, you cannot say that your livelihood. It's a case of your livelihood. It's a purely commercial interest. You do not have any right to challenge this notification. It is another thing that the Honorable Single Judge has recognized the right to be a traditional right. No, this finding itself is, in my humble submission, is not correct. If your Lordship permits me to go ahead with the findings further, my lord. And it is a, my lord, Ramsar, I do Lordship knows in Iran, in Ramsar Convention, my lord, certain sites were declared, and at the time the judgment was declared, there were 20. Now it is more than 20. It is one of the 3/4 wetlands we have in Assam, and it's a heritage site, my lord. There is a public interest involved Now, this private interest of of an organization who has got commercial interest should not weigh, my lord, above the public interest, my lord.
Right.
My lordship asked me to read from paragraph 19.
Yes.
May I continue, my lord?
Please go.
Page 275.
Yes.
Paragraph 19. In the above context, it would be appropriate to note the averments in paragraph 2 and 3 of the writ petition wherein where the petitioners have claimed to have exercised traditional fishing rights in the Deeper Bill and absence of any counter averments to such claim in the counter affidavit of the DFO. This is also not correct, my lord. In the affidavit we have filed, I'll show, my lord, we have clearly said that they do not have any fishing right or any other right.
Traditional fishing rights.
Traditional, they do not have.
Right.
It also needs to be highlighted that just because leasehold right was granted to the petitioners for a few years, the pre-existing traditional fishing rights do not get abrogated. This traditional right claimed by the petitioner was very easily accepted by all citizens with all respect, my lord. That ought not to have been accepted. Page 276, my lord. Moreover, when settlement under the fishery rules can be granted only to actual fishermen, the lease granted by the AFDC in fact corroborates the claim that the leaseholders petitioners are traditional fishermen of the area.
Yes, please.
My lord. Para 20 now I'm reading from page 276, my lord. The next aspect to be considered is the implication of the identification of Deeper Bill as one of the 26 Ramsar sites, which will require protection of the wetland under 2010 wetland rules and its substituted version, that is 2017 wetland rules. But the question is whether these rules actually apply for areas protected under the 1972 Act. It is relevant to note that Rule 7 of the 2010 wetland rules itself states that the wetland bodies, water bodies which are already protected as national parks and wildlife sanctuaries are to be regulated by the 1972 Act. Similarly, Rule 3 of 2017 wetland rules also makes it clear that the rules will not apply to the wetlands already protected under 1972 Act. Consequently, the inclusion of the Deeper Bill as one of the 26 Ramsar sites will not automatically attract the provisions of 2010 wetland rules or the 2017 wetland rules. I leave it to your lordship whether this interpretation is correct or not. Thus, the State Council argument based upon the provisions of the wetland rules in the context of the protected sanctuary is not relevant in this case. It will also merit consideration in the same context that in paragraph 41 of the counter affidavit filed by DFO, which is averred that the declaration of Ramsar site will have no legal implication on the Deeper Bill, but the same is relevant only to highlight the importance of the water body and its biodiversity status. In fact, the state has taken the stand that better protection is provided in notified wildlife sanctuary, and such a declaration by the state does not require prior concurrence of the central government. What happens from this is that the pleaded case of the state is somewhat different from what is argued in court. My lord, before I proceed further, if your lordship permits me, there is one more PL pending or it is disposed of where the issue was in Deeper Bill. It's truly a wetland and birds from outside India come at a particular season.
Migratory bird.
Yes. And my lord, somehow because of the fault of some of the officers in one department, during winter when people are on picnic spree, they go in small vehicles, my lord. One vehicle will carry the person who will enjoy there, and other vehicle will be filled with huge speakers. And hearing was going on here. I was sitting behind. I came forward to say that I am a direct witness to this disturbance created to the birds which come. There will be no bird, my lord, because of the sound, my lord.
Naturally, that would scare.
And this only court, my lord, in the PIL passed a specific order. Thereafter, it was stopped. And when I share it with my friends, they say you are responsible for taking our right to enjoy there. Well, I said I
enjoyment is visual, basically.
Yes.
Need not have music to see birds.
And it is really relative, my lord.
Bharatpur Ghana Bird Sanctuary is a world-renowned sanctuary.
Yes.
So it's only
very
the visual delights which are relevant.
People do not realize. It's very unfortunate, my lord. They think enjoyment is at the cost of these birds who are innocent, my lord. Well, para 22 I am reading, my lord.
Yes.
The direction of the Supreme Court issued on 3/4/2017 in WPC number so on the suo motu registration of PIL by the Jurisdictional High Court for the Ramsar Convention site should therefore be understood in the context of the state's decision to protect the Deepor Bill under 1972 Act. One cannot also remain unmindful of the fact that Central Wetlands Regulatory Authority under the 2010 wetland rules was constituted only on 14 to 2017, and therefore there has been no occasion to identify the wetland or to prepare the brief document to invite objections and suggestions from those who are likely to be affected by the declaration of the protected wetland. Therefore, the intended opportunity for the affected group is not yet provided. The 1972 Act itself has made provisions for protecting the rights of those to be impacted by the declaration of the sanctuary, and therefore the provisions for publication of notice and their circulation in the neighborhood to enable the affected category to make claim and file objections are substantial rights. Therefore, the procedural requirements which is intended to do justice for the impacted category to be reduced to mere formality is unacceptable, and hence contention to the contrary is rejected. Following the above discussion, it can be reasonably concluded that the MP notification of 21 to 2009 was not preceded by any required publication of proclamation, and we say under Section 21 of the 1972 Act. The departure from this earlier stand by the collector is not supported by any reason for the later decision. It also not clear why the government failed to consider the already available materials in the exercise undertaken during the inquiry made by the collector under Section 22 of the 1972 Act. The law requires the state government to make alternative arrangements to protect the rights of the affected persons, but notwithstanding the observation made by the collector on 7/1/1994 and the consequential government decision made on 29/5/2002 expressing the need for protection of the fishing rights for the petitioners, no attempt has been made to address the livelihood issue, which in my perception vitiates the process. Therefore, the declaration of sanctuary made under notification 221 to 2009 cannot be sustained in law, and the same is therefore. But at the same time, one cannot overlook the strategic importance of the, my lord, this is important, strategic importance of the water body neighboring the Guwahati city. There can be no dispute with the proposition that the Deepor Bill should be protected in public interest, as it can have a significant positive impact on the environmental of the area. Therefore, notwithstanding the above interference, the government in its wisdom is permitted to arrange for declaration of sanctuary status for Deepor Bill by initiating a fresh process and issuing the necessary proclamation in accordance with the provisions of the 1972 Act. It is permitted accordingly.
You'd like to ask question to the other side.
Gotcha.
The notification was of the year 2009.
Gotcha.
Challenge was given in the year 2018. Any explanation for the delay?
My lord, the writ petition
Yes, please.
was filed in 2009 itself. The writ petition, my lord, would find at,
The appeal is of 2008.
appeal was filed by the state in
Okay,
2008.
Understood. Very well, very well. Yes.
My
carry
lord,
on.
two more submissions, my lord, rest I have covered. My lord, there is one finding that there was no proper publication in terms of Section 21. Lordship, may kindly permit me to refer to Section 21(1). says when a proclamation by collector. When a notification has been issued under Section 18, the collector shall, within a period of 60 days, publish in the regional language in every town and village in or in the neighborhood of the area comprised therein a proclamation specifying as nearly as possible the situation and the limits of the sanctuary, and requiring any person claiming any right mentioned in Section 19 to prefer before the collector within 2 months from the date of such proclamation a written claim in the prescribed form, specifying the nature and extent.
Yes, please carry on.
My lord, your lordship will find that this notification was published in 2 local newspapers. Well, in course of the last hearing before this court, my lord, when your lordship predecessor was there, we were actually file one additional affidavit. We filed an additional affidavit saying that not only that, my lord, the collector invited objections, informed everybody. So what they almost singular says that your publication was not proper. Now, the procedure prescribed has been followed. We have published in the newspaper. The collector made other arrangements, informed others. Now, as I said, my lord,
Is it disputed that publication was not made? Is there any dispute?
they have taken a plea that publication was not properly made. they were not aware.
of the first notification.
My lord,
Subsequent one. 2000.
Subsequent one.
Subsequent.
so my lord, assuming that there was any, there was non-compliance with them. In fact, my lord, my submission is we have complied with the provision of section
This is
21.
something you have to explain, sir.
My lord,
Para 25,
my lord.
impugned notification was
Yeah.
not preceded by the required publication of proclamation.
My lord, it was. My lord,
How
lordship,
do you satisfy
my
the
lord,
court
my
on
lord,
this?
I'll take your lordship to the affidavit filed by the government.
Let us see the notification first.
My lord, notification and lot will find. Initial notification your lordship will find will be available at page 150, my lord.
150.
My lord. Yes. In exercise, lordship is court, my lord.
1989.
My lord. In exercise of power conferred under by section 18 of the Wildlife Protection Act 1972, the government of Assam is pleased to declare the area described in the schedule below to be a sanctuary in accordance with the provision of section 18 of the Wildlife Protection Act 1972, read with section 26 of the said act. The government of Assam is pleased to appoint ADO Revenue Kamrup to the collector to inquire and determine the existence, nature, and extent of rights, if any, existing in favor of any person or persons in or over any claim arising therein within the limit as determined in the schedule annexed herein, and to deal with such claims as prescribed in chapter 5 of the Wildlife Protection Act. This was the initial notification. My lord will find at page 83.
There is a
the
proclamation, please.
final proclamation, my lord?
No. Proclamation under section 21.
Yes, my, this is what I am saying.
Page?
Page 83, lordship may kindly see. No. Very good.
Yes.
And my lord, this is of 22/6/1993.
Mhm.
Then your lordship may kindly see. Lordship may kindly see local inquiry to be conducted along with the DFO in the middle of this letter, my lord. DFO, Assam State Zoo Division, Managing Director, Assam State Fishery Development Corporation, Director of Tourism, Circle Officer. Everything is there.
Publication in newspapers.
My lord, that is also there. Page 155. Page 155 and 156. Page 155 is the my local English daily Sentinel, the Sentinel.
This is 2006. So this notice
My lord.
is of 1990.
This one is 22/6/1993, my lord.
No, it's Annexion 9. What is the date of Annexion 9, sir?
My lord, I have written here 22/6/1993.
So this publication you are referring to is of the year 2006. 93 notification published in 2006. How is it to be explained?
No, my lord. Prior to that, my lord. Page 83 is of 1993. My
There
lord,
is a notice.
my lord.
How it has been published?
My lord,
Because publications you are referring to are of 2006.
my lord.
We can't accept.
Yes.
And that is notification of 96 was as a matter of fact published in 2006. 10 years down the line.
My lord, I'm just making. My lord, may I kindly turn to page 139.
Yes. Yes.
In fact, my lord, after the initial notification, this notice was there. Then there were some objections. Then there were some opinion given by the collector that no, some alternative arrangement should be made and all. After that, my lord, lord will kindly turn to page 138, paragraph 13. I will be referring to my. 138.
Yes,
para 13, my lord. That as regards para 8 and 9 of the petition, deponent begs to state that it is true, but however, in compliance of the order of 7194 passed by the collector as appointed by government notification number Spencer 12/1/1989, the principal secretary forest government was not kept the process of filing notification of the sanctuary in abeyance by his order communicated dated 29 May 2002. However, the government subsequently reviewed and withdrawn the order passed by memo number Spencer, by government notification number Spencer, dated 17/8/2002, and in the year 2006, the government was appointed by notification number Spencer, dated 5/1/2006, the ADC as the collector under the provisions of section 18B of the Wildlife Protection Act 1972 for inquiry into the and determining the existence, nature, and right of existing in favor of any person over the land comprising mass of water, popularly known as Dipperbill, in supersection of the government notification dated 12/1/1989 that was published in the Assam Gazette 22/3/1989. The newly appointed collector has given fair opportunity to local people to settle their rights and claims. The proclamation under section 21 of the Wildlife Protection Act 1972 was issued by the collector to all concerned inviting claims of right over any portion of the state land or objection against creation of proposed sanctuary that was published in the local daily in Amar Ahom, dated 31/5/2006 in vernacular, and in the Sentinel dated Spencer as per the collector's order dated 1/7/2006. No sort of objection on claim or claim of right over any portion of the land was received.
can you satisfy us, sir, that this duration of 60 days as indicated in section 21 is directory and not mandatory?
My submission will be, it is not mandatory, it will be directory. A time frame has been given, true.
There is again another time frame in subclause B.
B.
So the statute indicates that things have to be done in a particular period. Why should it be diluted?
My lord, as I submitted, my lord, these dates I cannot change.
You are really sincere
My lord,
in your attempt to declare the sanctuary,
my lord.
then you had that opportunity of doing it within a reasonable time. Even after the order of the learned single bench, what have you done?
My lord, after the order of the land single, since we changed here, we didn't undertake any fresh research because there will
Why
be,
not?
it will amount to,
That's what shows.
well, this will amount to
your
taking a
intent.
parallel proceeding which we are not permitted to do.
No,
my lord.
not
Your lordship is
You
insisting
are
of the matter.
already having a declaration
My lord.
that your proceedings are vitiated
True, my lord.
on account of non-compliance of statutory provisions. You have been given an opportunity to rectify yourself.
My lord, your lordship is correct. My lord, what I am saying is, my lord, we are agreed by this order passed by one single judge. We have challenged an appeal.
You could have.
We are
undertaken
waiting for
that.
the decision of the lordship.
No one prevented you.
My
But
lord,
all right.
my lord, once we start the exercise afresh pursuant to this lordship single judge's judgment, my lord, then nothing will remain in the
So
retention.
you
My
have
lord, my,
wasted 5 good years.
my lord, my submission before lordship is, my lord, with regard to this notice. It is true that it is meant some time frame is even given. And my submission before lordship will be that first your lordship will decide.
There is a period prescribed in the section.
My lord.
But you satisfy us that this is directory.
My lord, these aberrations little bit here and there, even if any.
Little bit.
My lord,
So
I,
after 10 years.
my lord, these dates, my lord, I cannot change before lordship today, my lord.
So all right, satisfy us
My
by
lord.
any judgment.
My lord,
That in a statute of this kind,
my lord.
the time periods, time limits which are prescribed are not considered as mandatory, they are direct.
My lord.
Satisfy us by any law. Otherwise, your entire exercise is useless.
Well, I'll do that. If the lordship direct, I'll do that. Well, my first submission
There
is
is
your
no
lordship.
reason to direct. It is there on the statute.
My lord.
It is facing us. It is in
My lord, my first submission actually was that this petition itself is not maintainable because they have got no locus.
irrespective thereof.
My lord.
This court has been apprised
My lord.
of us executive action, which is on the face of the record, contrary to the provisions of law.
My lord, that within time frame, even if it was not done, my lord, these have not prejudiced the petitioner, my lord, in any case.
For all we know, situations may have changed. The character of the deed might have changed. Birds might not be coming thereafter.
No, no, but it is still there like that. Water body,
The body is all right. What is replete with water body? God's bounty. But you were really so intent on preserving this fauna and flora. Why you were sleeping for years?
my lord,
Show us any law.
there was still, well, possibly there was a stay in,
Stay
my lord.
of what?
Of the
No, the process was kept in evidence paper. Page 138.
At your own end.
Yes, yes,
At your own end.
yes.
So would that extend the statutory limitation? It is not like 473 CRPC.
yes.
If there is a stay by any board, the limitation would get extended.
My lord, that is there. That is there. When my first submission will be, my lord, then it's not mandatory, it's direct.
What is the foundation of this?
That point was never taken. My lord. I'll have to cite some judgment on that.
You have to,
Otherwise, my lord, I'll urge upon your lordship to,
see on parity to see land acquisition. But the time frames are provided.
yes, yes, there, my lord, is
Yeah,
very
it's treated
strict.
to be mandatory.
Yes, yes.
So why should we hold to the otherwise in this act? And then, sir, there is a stay of the learned single judge order.
Yes.
What have you done in the meantime? Have you gone ahead with your decision?
If there is a stay of learning this order, that is our declaration will prevail.
What have you done in the meanwhile?
No,
In
nothing.
accordance with the declaration, have you taken steps to ensure that the fishing, the other activities which are required to be restrained?
My lord, yes, nothing is going on now, my lord. After this case, my lord, they are not doing this. Bill is intact. And wetland is intact. Only the decision is to be given. Yeah.
So you just satisfy us on this 60 days.
any,
Any,
and one thing, my lord,
Wording part, please for further hearing on
7th of party Tuesday,
7th
7th
of.
March.
any day convenient.
I'm sorry,
Holiday.
I'm sorry.
Holiday, yes.
We can have it earlier,
Lordship,
2nd March
lordship,
at 2 PM.
lordship. And lordship, the traditional fishermen, non-traditional, we are traditional from ages. Government in 1976 created a society from. And then my lord declared that area under the fishery. That's how we got alive.
My lord, traditionally fishermen have not come before your lordship, and it is
Yeah.
not a PIL.
Otherwise,
Your
we can't
lordship
be
is
given a
not
lease, my lord.
adjudicating the
The
claim
finding
of
of
a-
the single bench is that it's only traditional fishermen.
Yes.
Can-
In order to regulate their process,
Lord.
they've been given the leases.
That is factually not correct.
We'll consider, we'll continue.
My lord.
Matter number 19,
Under the 19, well, I appear for the forest department, we are filing a affidavit today, well, post of the day.
Affidavit,
There was a direction from this honorable court to file an affidavit. This is a motor case, my lord.
yes,
The status as on date with regard to illegal mining in a historical area, that was directed to be brought on record. If they file their affidavit, my lord, we can have it after a few days, my lord. I can also assist
Yes,
your lordship.
we'll
and
file it.
counsel for the forest department submits that he would be filing the affidavit in terms of
Order dated, my lord, 16/11.
order dated 16/11/22 during the course of the day. Re-notify or we can have it on 13th March,
Lordship,
13th March.
much obliged. Affidavit.
matter number 20,
Union of India.
May
Yes.
please, your lordship.
In fact, this matter, to some extent was heard by Honorable Mr. Justice.
It has been
Sumant Shah.
heard. Well, then we are benefited.
Here it is based, Lordship, whether-
Before that, my lord, before you start, my lord, on 8/12/2022, my lord, this honorable court passed an order, my lord, directed them to consider the aspect, my lord.
Yes, sympathetically.
Yes,
Lordship,
that, and thereafter also in subsequent steps, it was directed them to consider that aspect. But
Let us know
have
what has
come
been done.
that
Lordship,
cannot
in
be.
fact, I have taken it up with the authorities, Lordship.
Okay.
Now, here is a case, Lordship, that some rifles is combat group. Lordship. And in fact, he has not been in service since 2012. That is one aspect of the matter. He is out of training. Secondly, Lordship,
They have not considered your prayer favorably.
it
Yes.
has not been considered, and Lordship, he had also not withdrawn his letter for discharge and in time. So that creates a difficulty on our part.
That part we have withdrawn, my lord. How would get there?
No,
Need not argue with each other, sir.
Yes.
We'll try and adjudicate to the best of our ability.
yes.
Yes.
Now, Lordship,
So with this communication, are we ready to hear the matter?
Yes.
Okay.
That communication, my lord, what earlier, in our earlier occasion, what they have relied on, my lord, that contention that have been again reflected in the same letter.
Mhm.
The interim letter-
Discharge,
Yes, discharge.
voluntary discharge. Okay, very good.
here is a case, Lordship, where the respondent petitioner had enrolled into the Assam Rifles on 10/4/2002. And on 12/8/2011, Lordship, he had made a prayer for discharge that your Lordship will find at page 32.
He says that it is under coercion.
Now, Lordship, thereafter he says it's under coercion. Now, if at all, Lordship, that is assumed to be true, he files an appeal before the authority
Mhm.
1 year after his discharge,
1 year.
1 year after his discharge, which your Lordship will find at page 47. And here, initially, he had also taken a plea that he had withdrawn the
Resignation.
yes, but in this particular appeal, that fact is not disclosed. Lordship, this is, Lordship will see the date. It is 9/1/2013,
9/1/2013.
Lordship. So, Lordship, had he been diligent enough, Lordship, he was out of service from 1/1/2012. He could have immediately taken it up with the authorities, but he did not do so. After 1 year, he Lordship get some ideas, and now he says that it was under coercion.
Yes.
I take your Lordship to page 61, the order passed by the appellate authority. I take
Yes.
your that your Lordship was not page 61, Lordship.
The cantankerous man. Parody of this communication. The repeated punishments given to him.
That of course, Lordship, that can be taken into account, Lordship, while
All
considering the
right,
case.
place the appellate order.
This is the order, Lordship, at page 61. down.
This is the appellate authority's order.
Yes,
No, this is on remand by this court. Where
yes,
is the only original order in appeal?
this, he had not filed any appeal.
You
He-
just now pointed out that the appeal was filed after 1 year.
This representation was filed after 1 year, that is at page,
Sir, you
Yes.
just now argued, you pointed out the date
yes,
9/1/2013.
yes, Lordship.
So if that is an appeal,
No,
where is the
after-
order on that?
After that, he came to the court.
Okay,
He came
immediately.
to the court and court remanded it back to the authority to pass an order. And this is the order passed by the appellate authority, Lordship. And now I would take your Lordship to the order passed by the learned single judge.
Yes, please.
That your Lordship will find
No, that letter is there, my lord. Case 51, my lord.
Yes, we have seen that.
Case 51,
The first rejection of your representation.
If I may take your Lordship to page 86, the order passed by the learned single judge. The learned single judge,
Relies upon your communication circular dated 17th May
that's
or CRPF.
That's, yeah, it is a circular related to the CRPF. Lord. Now, it would have been a case under the SSB when the SSB did not have their own rule
Hmm.
and act. Then they were governed by the CRPF. Now, taking a CRPF Lordship circular, the learned single judge I'll take your Lordship to page 93, Lordship. From paragraph 22 onwards, if I may read it. This court has observed, and also it is not in dispute, that the petitioner submitted an application for discharge on 12/8/2011. Lordship, it is not in dispute, but he disputes it. He says, I have not filed it. I have withdrawn it. It is order on record that the same day, on 12/8/2011, the authority convenes a standing committee to consider the application of the petitioner. It was under the same day, on 12/8/2011, that the recommendation of the committee to accept the application of discharge of the petitioner was accepted by the commandant. It was also on the same day that the respondent authorities obtained an undertaking certificate from the petitioner as quoted above. Perusal of the undertaking certificate would indicate that the undertaking was only to the effect that the petitioner understands that in the event of his discharge at his own request on extreme compassionate ground being sanctioned, he would not be entitled to any pensionary benefit for the service rendered. This undertaking does not at all deal with the issue as to whether he had given the discharge application voluntarily or not, and whether the authorities explained to him to the implications of such discharge application in terms of his income. The said undertaking merely refers to the fact that in the event his application is
Do
accepted.
we have any guidelines in the Assam rifles? How the committee is to examine the applications for discharge?
Not, Lordship, that is.
Then the learned single bench was justified in saying that the procedure which is applicable to similar paramilitary forces should be applied. What is wrong in it?
I would just take your Lordship to,
There must be an SOP for the standing committee. Can't be that they have no guidelines at all.
Lordship, at least I have,
You try to find out. You should have your officer in charge with you in these matters.
I can have him here, Lordship.
You ask him to bring his, there must be some procedure
Lordship.
how the standing committee is to proceed with such cases.
Lordship, I can have him here on the Friday.
You ask him to be here.
The learned single judge has held that the initial procedure of accepting his application for
Yes.
discharge itself was faulty.
Yes, Lordship.
What is the SOP for that? How do you do it?
वही तो
Lordship,
क्या
that has-
पढ़ने के that committee in absence of any material or documents to record as to how the committee had
That, Lordship,
that's something. They did not even interact with the employee.
Lordship, if
The
I may-
only argument which is somewhat convincing on your behalf is delay in filing the representation. But well, in these matters, these are cases of grave hardships. The man loses all service benefits.
Lordship, I am with him on that. But if I may take your Lordship to page 31 to page 36. 31 is the application for discharge. That is in English. The original, your Lordship will find at page 32.
Yes,
The convening order,
32.
convening order at page 33, Lordship.
Yes.
And
The very same day.
no, here is a case, Lordship, where the commandant cannot discharge him.
Yes.
The
So the
commandant.
committee is convened on the very same day.
Yes, Lordship, that is true, Lordship. Then it has to be referred to
No,
the
no,
Director
sir,
General,
look at this.
Lordship.
The committee doesn't even say that they have examined the person incumbent. And where was the occasion to mention that no undue pressure by any authority? Where
Lordship,
was the occasion for the committee to make such observation without examining the man?
Lordship,
That is what creates grave suspicion.
Lordship, I will ask the officer to be present with that. Lordship, because
You
what I
seem
have
to
seen
be-
is,
Seem to be in a fix after the query.
Lordship,
कुछ भी नहीं मिलेगा. He'll not get anything at all. It's too harsh. If at all you can use your good offices,
Lordship, I
advise
have
them,
tried my
he
level
would
best.
give up the intervening period, at least the financial benefits.
Lordship, I have taken it up with the authorities.
They are not inclined.
That is the,
But then your proceedings will not survive in view of what we have observed. This phrase, no undue pressure by any authority.
yes, Lordship.
Where was the occasion? They have not mentioned that they have examined the person.
Lordship, that
Then
is.
why these
that is
words?
it. That is the Lordship. That is it.
Where is the approval? Where is the approval by the higher, the HQ? He has submitted a withdrawal application on 26th August. So
That we dispute, Lordship. That is not on record.
that is on record of the writ petition at least.
That is,
Where is your approval by the HQ?
Lordship,
Can you point out, sir? Where is the approval? The committee has simply forwarded it to the HQ.
Yes,
So
Lordship.
where is the approval?
I'll try to get it out from the record, Lordship.
And the approval must have been communicated to the man.
Lordship,
1/1
I have it.
2012. 1/1 2012. Where
yes,
is it?
Lordship, with the records I have,
This is annexure F. Service pension.
no, that is not there in that.
That is denial communication that you are not entitled to
Yes,
pension.
Lordship.
In the first rate, it was annexed as discharge certificate dated 3/12/2011.
Lordship. I have that in the record, Lordship.
Can we see that?
Heavy এখন আছে না এটা? বহি এখন আছে।
You call your officer on the next day.
Yes, Lordship.
List on
Friday, Lordship.
a pertinent query was put to learned counsel for the appellant regarding the procedure to be followed by the standing committee for dealing with the application for voluntary discharge. He seeks short opportunity, complete his instructions. List on 3rd March, 14th March.
Item number 21.
State. No one to represent state.
Judgment document page number 117, no?
We'll take up.
R. Mazumdar, here for education. I am for BTC.
Second round. We'll pass it over, come in the second round.
My lord.
Oh, my.
At 2 o'clock, my lord.
Very well. Very well. Two.
Item number 22.
कोई नहीं. No one.
May please, your Lordship.
Yes. The High Court matter.
Other similar matters are pending.
No, my lord, in fact, at page 63, my lord. Page 75, my lord. My lord, when a review petition was filed, my lord had passed the order. At page 76. Page 68, my lord, page 68.
68.
Yes, my lord, page 68. Effective part is at page 70, my lord. At the bottom.
Amicable settlement. Minimum wage.
Yes, my lord.
There's a regular employee. After Yes. Hmm. Hmm, hmm, hmm. Minimum pay scale. Then put
Yes, my lord, as per the review judgment of 82/2013, there were three conditions that were laid down upon us. That is that by through amicable settlement, at page 70 is the order, that their service will not be dispensed with till the age, attain the age of superannuation, that they will be paid wages minimum the regular pay scale, and that at the time of the superannuation, they'll be brought under the medical insurance scheme. However, we just agreed to the first two conditions, and for regard to the third condition, my lord, we were asked to give in a representation to the government for considering our pension. My lord, our pension was not considered. And my lord, what had happened is that with the second point, my lord, where the minimum wages, we did not get our allowances. We were getting our allowances at the beginning, but without any office of this honorable court or of the judicial department, they stopped giving our allowances. We filed a writ petition stating with regard to Upen Das and a Jagjit Singh 2017-1 SSC that we are eligible for allowances, because the lordship, the word is very much clear here, is that they should be paid minimum wages of the regular pay scale. The scale is inclusive of allowances, and that's why we should be allowed to at least have our allowances on that regard. And my lord, in fact, the government order with regard to pension, my lord, they have not considered the entire facts upon the establishment pension that's been there, because we as retiring on age of 60 years, there are other rule 39 and rule 63 that has to be taken in by, but the pension order is silent about it. And top of that, my lord, I would like to take to page 117, my lord. Page 117 of my appeal, my lord. My lord, this is a notification of the governor. Where, my lord, may I read, my lord? The following are hereby notified for compliance of all the state government departments applicable for the master role workers, casual and similarly placed employees who were appointed prior to FRBM period September 2005. Minimum pay scale plus grade pay plus medical allowances plus everything. And this was an adherence to the state of Assam versus Upen Das. And state of Assam versus Upen Das is a following of the judgment of Jagjit Singh versus state of Punjab. State of Punjab versus Jagjit Singh. My lord, my only consideration before this honorable division bench is that, my lord, we should be paid our allowances, because as per this review order, it has been clearly said we should be paid minimum wages of the regular pay scale, and the scale is inclusive of allowances. And my lord, in fact, there was a submission by the council of the state council where they had clearly stated that my lord, that is on page 142, my lord. If my lord may just look into it. May I read, my lord? Page 142.
yes.
At the bottom, my lord, Mr. Nayak submits that the final decision in this regard is yet to be taken by the finance department. This is regarded to pension, my lord. That sending council of finance department reflecting a view that if the petitioners are appointed on or before 27, they would be eligible for the entitlement as specified therein, includes medical allowance, dearness, and housing allowances. Mr. Nayak submits that a final decision is yet to be taken by the finance department. Mr. Naik also submitted by the next date fixed, perhaps a decision would be taken, which would be brought on record before this court by means of an affidavit. This affidavit was never filed, and thereafter, my lord, the learned single judge heard the matter, and it has held that because we have a checkered history.
Yes, Mr. Counsel, why pay scale would not include allowances?
In that case, I have to refer to the justice judgment itself, Lordship. Lordship, I'm referring to 2017 1 SCC Lordship 148. It's State of Punjab versus W. Singh.
Yes.
Case 222 Lordship, paragraph 55.
222.
Yes, sir. Paragraph 55. May I read out? In view of all our above conclusions, the decision rendered by the full bench of the High Court in After Singh versus State of Punjab, dated so and so, is liable to be set aside. And the same is hereby set aside. The decision rendered by the division bench of the High Court in State of Punjab versus Rajinder Singh is also liable to be set aside. And the same is also hereby set aside. We affirm the decision rendered by the State of Punjab and versus Rajinder Singh with the modification that the employees concerned would be entitled to the minimum of the pay scale of the category to which they belong, but would not be entitled to allowances attached to the post held by them. Lordship, learned division bench, Lordship, in this case, Lordship, it directed for giving minimum of the pay scale along with admissible allowances attached to that post, Lordship. Lordship, to the second portion is concerned, the Honorable Supreme Court preferred to modify. Lordship will come to the next page, Lordship, paragraph 61. Paragraph 61, Lordship. In view of the position expressed by us in the foregoing paragraph, we have no hesitation in holding that all the temporary employees concerned in the present bunch of cases would be entitled to draw wages at the minimum of the, I'm referring to the word.
Temporary employees now.
Yes, sir. Lordship, kindly, in that case, Lordship will.
They have been categorized as temporary employees.
Not
Even
temporary
as on
employees. No, they are not temporary employees. Lordship, kindly see the first judgment, Lordship. At page 60, Lordship. 5153, 2010, Lordship, paragraph, page 60. It's a division bench judgment, Lordship. I'm coming to page 64. Second paragraph, Lordship. As far as the present petitioners are concerned, they were not appointed against any regular sanction post, and their appointments were admittedly made in terms of the requirements of the scheme. Whereunder, the fast track court has been established and functioning preceding publication of the notification aforementioned. With the abolition of the said scheme, the petitioners do not have any right vested or otherwise in law or equity to claim appointments as against the said sanction post. For making, therefore, the said 20 permanent court functional.
But then they were granted permission by Honorable Supreme Court to file a fresh petition.
No, against this,
certain directions have been given.
Lordship will kindly see the extent to what extent they were allowed to file the review petition, Lordship.
All right.
Page 66. Learned counsel appearing for the petitioner submits that the main prayer with regard to fixation of pay scale equivalent to the pay scale given to the regular employees has not been considered by the High Court. A perusal of the order of the High Court would indicate that the point was not raised.
Pay scale can't be granted to a temporary employee. Pay scale presupposes a different kind of status.
Here the submission before the Honorable Court was that they were not considered for minimum pay scale equivalent to the pay of the regular employee.
That is why they were given liberty.
To that extent, Lord. To that extent.
The court again. Then the court drew a particular formula wherein they have been given the minimum of pay scale.
Lord.
They are not temporary employees. How do you satisfy it?
No, in the next division bench judgment, Lord, we are page 70. To what extent they were given the benefit, Lordship? Bottom, Lordship, page 70 at the bottom, Lordship. And on 16/12/2016, for the amicable settlement of their dispute, the learned senior additional advocate general made the following offer. Here, that their services will not be dispensed with, but for disciplinary action till they attain the age of superannuation.
This is not the status of a temporary. Temporary employee, there is no question of granting such protection.
No, initially, Lordship, when the matter was decided in the year 2010, the Honorable Court clearly declined to regularize their service.
Right.
And the court passed in direction, you are there until and unless these posts are filled up by regular appointment. That is, an advertisement was already there. They were on.
Whether you filled the posts?
Yes, those posts we have already filled up, Lordship. But because of this order, Lordship, government has given an undertaking that, okay, till the
They
age of.
will be allowed to work till superannuation.
Yes, Lordship. Second condition.
There can't be a concept of superannuation for a temporary employee. This is extortion. You are using them, you are utilizing their services as if they are regular employees. Or they are working hours shorter. Why the government is supposed to act in this manner?
But this was the undertaking, Lordship. In dear Lordship, Honorable, this was the undertaking, and on their agreement, Lordship, this decision was passed. Second condition was that, Lordship, that they will be paid wages minimum of the regular pay scale.
So pay scale, that is what his argument is. That since we are not temporary employees and we have been given minimum of the pay scale, the allowances are attached to such pay scale.
That is why, Lordship, I referred that
That is, the Supreme Court says temporary employees.
No.
If there is a little slight bit of difference, satisfy us that they continue to act as temporary employees.
No, they were acting, they were working on the basis of the undertaking given by the state government that your services.
Right now, you have given an undertaking that you will continue them till they attain stage of superannuation.
Lordship.
So how they can be branded to be temporary employees?
No, Lordship, the judgment I am referring, Lordship. Here also employees were contractual, ad hoc, and similar nature of employees, Lord. Yeah, it will-
Mr. Sharma,
Yes, my lord.
you see, the Honorable Chief Justice, my lord, has already expressed that these people actually are not temporary employees, but that is another matter.
Yeah.
The problem is in the first round,
My lord.
the order of the court was to show you the door
Yes.
and fill up these vacancies by a regular selection process.
My lord.
So when you went to the Supreme Court, a review was filed.
My lord.
It was due to some initiative from the bench that the then division bench felt that something should be done for them.
My lord.
And therefore some queries were made, and I was also part of that bench on some benevolence being shown by the then Chief Justice bench. The government advocate, the learned additional AG came and said, all right, we will continue with them. It was passed in some other matter also. We may not be able to regularize them because of Umadevi judgment, but we will give them those benefits so that they can continue in service and retire.
Yes,
So these three things were.
my lord.
So that order you accepted with your eyes open.
Yes, my lord. I accept.
Listen.
Yes, my lord.
You don't listen, you may miss out.
Yes, ma'am.
You accepted that order with your eyes open.
My lord.
Correct. That was a kind of a via media, a solution was found to the existing problem.
My lord.
A strict legal appliance of the rules would mean that you had to leave, your client had to leave. So we were conscious that you are having family members, you have spent already long years with that. So some protection should be given. Now, if you want to reopen this issue now, then even the order by which your services were allowed to be continued, will that also not be reopened? And in that case, you will be running a list. Although in principle, we agree that people should get.
But the earlier judgment that is a roadblock.
May I just place here, my lord? My lord, I am saying the interpretation of the word paid wages, meaning of the regular pay scale.
And what about this observation
Then the paid
in
wages,
Jagdeep Singh's case?
my lord,
On which you
Jagdeep
place
Singh-
reliance?
in Jagdeep Singh, there were two sets of employees that had gone. One was for daily wage workers. My lord, just read the paragraph just down below that. So where my friend has learned pointed out, he has missed that paragraph. Where, my lord, I may just point it out to you, if my lord allows me to. We at page 56, my lord. Sorry, at page paragraph 56, page 222. We shall now deal with the claim of the temporary employee before this court. So there were two sets of employees, my lord, they went. One was daily wage workers, and daily wage workers were the one for the state of Punjab, which is Ranjit Kumar. And thereafter, we're dealing with temporary employees at page paragraph 61, page 224. In view of the proposition expressed in the foregoing paragraph, we have no hesitation in holding that all the temporary employee concerned in the present bunch of cases, temporary employees were concerned, would be entitled to draw wages at the minimum pay scale at the lowest rate in a regular pay scale, similar to mine.
How are you treating them in their service records? How are you treating them in the service records?
Yes, just continuing, Lord. They're not
In
even
what
temporary.
status? What is the status shown in this?
They're not regularized. They're permanent but not regularized.
What is the status? We know they have not been regularized. If they had been regularized, there's no question of minimum pay.
They were not regularized. That is why they have been given minimum pay.
Let me understand, gentlemen, how you are treating them in the service record. Daily wagers or temporary employees?
Not temporary, Lord. For temporary,
Daily
also, they
wages.
will have to
Are you
attend
sure?
the regularization status.
Daily wagers, are you sure?
Not daily wages, but similar nature of work, Lord. They are getting
Do you pay them, calculate salary on the basis of days they have worked?
no. They are given salary at the minimum of the pay scale.
Pay scale similar to what a regularly selected employee gets.
Yes.
The scale is different.
The scale
So
is
they are not daily wagers. They are temporary employees, assuming, who are continuing in the directions of the court. They are making payment of pay, minimum pay. The allowances at that very rate, they would be admissible as a consequence. The state tries to act in this manner to exploit the employees. Person who was regularly, they were given an expectancy. The past courts work for say 10, 15 years. They were selected in whatever manner. They served the system. You were trying to throw them out. The court found a way. Similar action has been taken for the court managers now.
No, Lordship. In
For
fact,
the IT staff in the High Court.
I understand, Lordship, but in the year 2000 itself, this honorable court said, you are there only till the completion of the regular employment process.
They continued.
They
Are they
can,
not,
yes.
are they offering some lesser service as compared to your other employees? Allowance you should give, sir. This is
Lordship, recently, we have filed one affidavit.
reassemble at 2 o'clock. You can take a suitable date, whatever is. Accepted, please. दे दीजिएगा डेट दे the one which is going on, we are concluding. Yes. Okay.
Item 22 to continue.
21, my lord. 21, day after tomorrow.
You can take a suitable date. We are having some emergent work.
Hello.
So you can take a suitable date.
Okay, Lord. Oblige, my lord.
Grant the date. Yes.
Yes, my lord. My lord, in the state of Punjab, is Jagjit Singh, my lord, there were two sets of employees. One who were the daily wage workers, and the second one was a temporary employee. For the daily set of wage workers, it had held that it will be gonna get a minimum pay scale, but without the allowance. And whereas for the temporary employee, my lord, it had been stated that we would be receiving the minimum pay scale.
Okay.
And my lord, it has been cleared, as my lord may read para 2 at page 161 of the judgment.
Yeah.
If I may read, my lord. A division bench of the Punjab and Haryana High Court in the state of Punjab versus Randhir Singh set aside an intra-court appeal. The judgment landed by the learned singles of the High Court. Randhir Singh versus State of Punjab. In the above judgment, Learned Singh had directed the state to pay the writ petitioner who were daily wage workers, working as pump operators, fitters, helpers, drivers, plumbers, chowkidars, minimum of the pay scale revised from time to time. Then, my lord, at para 5, next page, my lord, page 162, my lord. The issue which arises for our consideration, whether temporary engaged employees, bracket, daily wage employees, ad hoc employees, employee appointed on casual contractual employees, and the like, are entitled to the along with the DNS allowances on account of the performing the same duties, which are discharged by those engaged on against sanctioned post ? So these were the issue there were. So there were two sets of employees, my lord. The first set of employees, they said there are no allowances, but for the second set, they said that you will be stagnant on the one basic scale of a regular employee, but you will be getting your allowances. In fact, my lord, we were getting our allowances. We were getting our allowances. But after the judgment of this honorable court, we were, but they stopped. And thereafter, being aggrieved by that, we approached this honorable High Court.
Is there a pleading in your writ petition?
Yes, my lord.
Read, please. Read, please.
Yes, my lord. My lord, may I read the prayer?
Yes.
So direct the respondents to provide the
Not
petition.
the prayer where you pleaded that you were getting and they have stopped it.
Yes, my lord. This is precisely, my lord, page 15, para 15, page 53.
53.
Yeah, page 53, my lord. Para 15. My lord, at the bottom, my lord. This is precisely the reason as to why the petitioner number 2 was paid his salary with all the admissible allowances for the period from September 2017 to January
But the
2018.
others have, this is an exception for petitioner number 2.
Yes, my lord.
The
He
others
was,
have not been granted.
others are not
So
been-
that doesn't help you much. Yes. Yes. Yes, please.
Lordship, may kindly see the order passed by the learned single judge, Lordship. I'm referring just one paragraph, Lordship. May come to page 154, Lordship. 154. Slightly longer paragraph, Lordship. 18. It appears that the present claim agent offsuit of the initial writ petition WPC 5153/2010, wherein the point was never raised, a fact which has not only been considered but also recorded by the Honorable Supreme Court in its order dated 12/4/2013 in SLP so and so. Thus, but for the liberty granted by the Honorable Supreme Court to raise the issue of pay scale
There is no thing of past. Liberty was granted. The division bench has extended the benefit of minimum of pay scale. Only issue for us to see is whether minimum of pay scale would include allowance. Your argument based on the particular paragraph number 55
yes,
is for temporary employees.
no, my
They are daily wages. They are not daily wages. That is what
no, they're
you
still,
admitted.
they're still fixed pay, Lordship. They're still fixed pay,
Yes, temporary. Assuming they are temporary.
not temporary, Lordship.
What is pay scale? Can pay scale be fixed for?
They are not given the pay scale. They are given at the minimum of the pay scale.
So whether that is a fixed,
Yes, that has their pay has been fixed at the minimum of the pay scale. That is,
so when the pay scales of the regular employees are revised, do they get the benefit of revision or not?
yes, Lordship.
So then how it is a fixed?
No, it is fixed at the
They are
minimum.
dynamic. Minimum, yes,
Yes,
we
Lordship.
understand.
Lordship,
But in the minimum even, the revision always takes place.
Lordship, even in case of fixed pay employees, Lordship, it is revised after 3-4 years, Lordship. Initially, they were,
Here the pay would be revised along with the revision as directed by state.
In the next,
In act, as per the statute,
yes, Lord.
the dearness allowance is added.
DNS allowance, in their case, Lordship, initially it was wrongly given to one of the petitioners.
Forget about that. We are not going on that
Lordship.
problem. The issue, plain and simple, is that your distinction which you are trying to draw from Jagjit Singh, that observation is only in relation to daily wages. They are not daily wages by any stretch of.
But they are not temporary, Lordship.
Okay, very well.
Lordship, in one more submission I would like to
Yes.
make, Lordship. In another case, Lordship, that was WA 45 of 2014. There also similar order was passed, Lordship. And in terms of that order, Lordship, Finance Department has issued one notification. And the cases of the petitioners, Lordship, were sent to the Finance Department for consideration for granting the relief in terms of that notification. Lordship, may I kindly see that notification? Take that.
117, my lord.
117, Lordship.
Yes.
In their cases, Lordship, some benefits were given. Though this notification was subsequently corrected, Lordship. Here, Lordship will find the first word used, minimum pay scale.
Yes.
It subsequently, the authority realized that it should be minimum of the pay scale. Accordingly, this
Right,
notification was,
but the allowances are there.
in this case, allowances. But
Then if in that case allowances are there,
Lordship,
they are on a better footing. They
Lordship,
are not on must roll, they are not work, they are not casual.
Lord, these are master or Lordship.
Counsel, please don't make such preposterous argument. These are must roll employees.
They are not, they were
So that is what
contractual.
we are saying. They would be on a better footing than employees on must roll.
They were contractual at a fixed pay pursuant to a scheme, Lordship. And the scheme and the post were co-terminal.
Situation is changed now. Now they are temporary employees drawing their salary from the law department.
That is
Or
my,
the- or the
that
High
is,
Court.
that is my humble understanding, Lordship. They are not temporary employees. They
Okay,
were
very well.
as it is. They are,
What is their, how do you classify it? Or how do you define
their
that?
salaries are given from the head of fixed pay. Other fixed pay employees are getting,
You may be giving them salary from the head of fixed pay.
Lordship.
What is their designation in the department? Let us know. Any document to that?
Someone is working as a stenographer, I think.
That is my post.
That is the post.
They're given salaries as a grade 4, Lordship. And that is why, Lordship, pursuant to this notification of the Finance Department, Lordship, others have been given the benefit, but only except one petitioner, Lordship. Others have been already given the benefit.
Of what?
In that regard, Lordship, I have filed one affidavit, Lordship.
Benefit of what, sir?
A benefit pursuant to this notification. In this case, Lordship, they have been given the DNS allowance. They have been given the medical allowance also.
Then what remains? You say that they have,
In
No,
case
my
of
lord,
others,
we have not
Lordship,
received any
Only
benefits.
one petitioner remains.
My lord, no,
then why you have excluded one?
no, we have not.
Because Lordship, this notification do not cover their case because Lordship, here the scale is fixed. Payment is fixed and he is already drawing more than this scale, Lordship. That is why he has.
My
not
lord,
been
may
given
just, my lord may just look the affidavit of opposition, para 6, 161. That the read applicant except the read applicant number 1 got the benefits of medical of the pay scale, minimum of the pay scale, which includes DA and medical allowance in terms of, and whereas read applicant number 1 did not get any further benefits in terms of salary, and he was already drawing the minimum of a scale of 14,000 plus grade pay of 7,000. And this is the notification which they enact. So they have never gave us the minimum scale, my lord. My lord may just read the, with reference to the above.
You have not counted this assertion. But the appellant number 1 is already drawing.
No, my lord. This is just a submission, my lord. He has, but we have never got it, my lord.
Except appellant number 1, Lordship. Others are presently getting minimum of the pay scale
And allowance.
plus DA plus medical allowance plus other medical allowance.
My lord,
That is the.
My lord.
Other than DA, what is the allowance?
Medical
DA,
allowance.
Get HRA.
DNS and my lord, as per the law, we would be getting DNS allowances and the medical allowances. And my
That
lord,
is what they have given already.
ma-
to the-
my lord,
That
they,
is given,
You have
Lord.
not counted this affidavit, sir.
my lord, they have not, my lord, on my lord, it's on record, I may submit, the petition, appellant has not received it.
Counter this affidavit. You
My
have not done it. You have been hearing the matter for almost 45
My,
minutes.
my lord, this is an affidavit in opposition they have filed, but they, my lord, the same, they have never, my lord, just read the notification they have relied on. Just read the notification, my lord, relied on, my lord.
The notification was already there. He referred to it earlier.
No, my lord,
It's
this is
already on
no, my lord, this is a different notification. In the
2019
date of notification
2017, my lord.
19.
19.
No, my lord, Annexure B, my lord, the notification which is annexed in the affidavit of opposition. With reference to above, I am directed to say that pursuant to the Honorable Guwahati High Court order dated passed in has been constituted in Finance Department student the list of master world work charge fixed pay casual workers who have been working with the system since more than 10
This
years.
is simply constitution of committee.
Yes, my
But
lord.
their affidavit says that you have been given the allowance.
My lord, we have not received.
Council, this is too much. We have not refuted this affidavit. What should we now understand?
No, my lord, as a matter of right, my lord, affidavit in reply, we ought to have, I'm giving a submission, my lord, here itself that
Your oral submission as against their affidavit.
my lord, as we have not received as on date, no,
This is too much. Didn't expect this. This council, you could have pointed it out at the outset. You should have said so at the outset. We need not have wasted so much of time. April. List on 27th April as paid.